and the land use is basically set by the state of Virginia as to what can be assessed and what cannot be assessed, and the prices it is to be assessed at and the prices not to be assessed at, whether it's farmland, timberland, pasture land, those type of things. So, I mean, I think that Mrs. Carter is certainly following through on what she's required to do by state code. But again, we'll get those answers for you and provide them to you. Okay? All right. Moving on to the next item on the agenda, which is under public hearings. And the first public hearing, or the only public hearing we'll have this evening, is an ordinance to amend Chapter 7, Emergency Services, Section 15.1 through 15-12, and 15-20 of Chapter 15, Public Safety. Section 50-2 of Chapter 50, Fireworks, 51-1 of Chapter 51, Fees for Emergency Medical Services and Ambulance Transport, Section 53.1 of Chapter 53, Hazardous Materials, and Section 72-6 and 72-7 of Chapter 72, Open Burning of the Code of Caroline County, to set forth the duties and responsibilities of the Fire EMS Chief. Mr. Pardon, you're going to be the spokesperson?
Yes, sir, I will.
Right.
Mr. Chairman, members of the board, if you'll permit me, I have a prepared statement that I'd like to make to introduce this subject tonight.
Please.
The subject of tonight's public hearing is to consider recommended amendments to the county code to set forth the duties and responsibilities of the Fire EMS Chief. The proposed amendments were the subject of a first reading at the board's September 22nd meeting and have been properly advertised for public hearing tonight. Earlier this year, the board approved the reclassification of the Director of Fire and Rescue position to Fire EMS Chief. This action represented a very significant and fundamental change in the direction of the county's emergency services system. For the first time, all emergency service providers, including volunteers, will be consolidated under what Mr. Rozelle has referred to as a strong chief. The result is that all units and personnel will operate under a defined chain of command, minimum training requirements, and standard operating procedures. Standard vehicle and equipment specifications and replacement schedules will be developed and adhered to. In short, authority and responsibility for all administrative, financial, and operational functions of the county's fire, EMS, and emergency management activities will be vested in the chief. The need for this change is perhaps best reflected in the fire and EMS study completed by representatives of the Virginia Fire Services Board, the Virginia Department of Fire Programs, and the Virginia Office of Emergency Medical Management in November 2006. The study concluded, and I'm quoting here, "It is critical to recognize only one position as a central authority and leadership position. It is felt by this review committee that this single item is the most overall important and critical issue noted. This fundamental reorganization and consolidation will have a ripple effect on all other areas of the study and will adversely impact the success of all recommendations if not implemented. The proposed ordinance amendments are designed to give the fire and EMS chief the authority needed to carry out the responsibilities that staff believes the board intended when it created the position. Since the Director of Fire and Rescue position had limited authority, the county's existing fire and rescue ordinances are very limited in scope. A complete overhaul is needed, therefore, to meet the new mission. The amendments proposed during the first reading at the September 22nd board meeting accomplished this. Since September 22nd, staff has reviewed the proposed ordinance further and recommended additional changes outlined in the red line version, if you will, that's included in the board's packet tonight. The essence of the ordinance remains the same. We have simply, in our opinion, fine-tuned the ordinance a bit. The reason for the proposed changes can be summarized as follows. 1, to clean up non-substantive errors discovered after further review. 2, to incorporate previously adopted fire and rescue-related ordinances with appropriate title and procedural changes to reflect the reclassification of the Director of Fire Rescue position to Fire EMS Chief. 3, to include changes or clarifications suggested by board members. And 4, to include changes that staff believes improve the ordinance. A redline copy outlining the changes to the September 22nd version was made available to the public through the public hearing notice that appeared in the Caroline Progress and also on the county website. Copies have also been provided directly to the volunteer chiefs and captains. With your concurrence, I'd now like to highlight some of the changes from the September 22nd version to tonight's version. Starting with section 15.3, which is composition. The language added in section 15.3 composition clarifies that fire and rescue companies and squads, while a vital component of the county's emergency services program, are not county departments, and volunteers are not county employees. Next, under section 15.6 leadership, and section 15.7, compliance with regulations and policies and penalties. Before I review this section, I want to highlight an important part of the ordinance to help put the language in context. As I indicated earlier, under the proposed ordinance, the Department of Fire and Rescue is reconstituted to include volunteers and placed them under the chief's authority. And so when we refer to the department now, you have to keep in mind that that includes volunteers. This is a basic tenet of the ordinance. Under section 15.6E, we have clarified that the chief's review and approval of volunteer members of the department applies only to new volunteers. In other words, existing volunteers will not be asked to reapply. However, criminal background and driving record checks will be undertaken periodically to ensure that existing volunteers remain eligible for service. And the same is also true for career providers. Staff has expanded the language in section 15.6G to more clearly explain the process for reviewing the criminal history and driving records of volunteer applicants and existing volunteers. Under the amended language, the chief is given the sole authority to reject new volunteer applicants if, in his judgment, their criminal history or driving record background renders them unsuitable for service. This is a change that was incorporated to ensure a standardized review process, and also establish a centralized record management system in the interest of public safety. If the chief determines after an investigation that the results of a criminal background check or driving record render an existing volunteer unfit for service, that volunteer may be suspended or terminated after the chief consults with the appropriate company or squad leadership. The process described above would also apply in the event of an allegation of a violation of department rules or regulations. In either case, the volunteer may appeal the disciplinary decision or action to the county administrator. The chief may also suspend the authority of a company or squad to operate as an emergency medical or fire service provider in the county in the event of an allegation that departmental regulations or rules have been violated. If an investigation substantiates the allegation, the chief, after consulting with the appropriate company or squad leadership, may make a recommendation to the board of supervisors to revoke the authority of the company or squad to continue to provide emergency services in the county. Moving next to section 15.20, which is reimbursement of expenses incurred in responding to DUI and other traffic-related incidents. The references in this section are regarding the reimbursements to volunteer rescue squads or fire companies have been removed, simply because the squads and companies are now again part of the department and financial oversight has now been vested in the chief. Other changes are simply to consolidate all remaining fire and rescue related ordinances under the revised ordinance and make any necessary title changes. Specific dollar values for fees for emergency medical services and ambulance transport have been removed from the ordinance so that if the board wants to change those fees, they can be done by policy and not by ordinance. Staff has proposed the recommended amendments because we believe they are necessary to provide the legal framework the chief needs to successfully perform the position as staff understands the board wants it to be done. In developing the ordinance, staff reviewed examples from other localities, several other localities as a matter of fact, that have implemented this model, the fire EMS chief model, and we've attempted to take the best from each of the ordinances that we looked at. As previously mentioned, the reclassification of the position from fire and rescue director to fire EMS chief, it signaled a fundamental change in the way the county provides emergency services to the public. None of the recommended changes are designed in any way to denigrate the efforts of our fire and rescue volunteers. The hard work, dedication, and sacrifice these individuals make for no reward other than knowing that they've served their communities is truly remarkable, and not to mention the vast sums of money that they save the county by providing these services for no pay. In conclusion, we believe the fire EMS chief model was selected to assist the volunteer system by streamlining the administrative requirements and ancillary duties that have become so time-consuming to them. Our belief is that this new model will allow more time for volunteer companies to direct their attention to operational response and training requirements. Concludes my remarks, Mr. Chairman. I'd be happy to try to answer any questions.
Thank you, Mr. Pardon. Does the board have any questions? Mr. Pardon, Mr. Popowitz, Mr. Thomas, Mr. Seeley?
Not at this time.
Mr. Rozelle? No. All right. Thank you, Mr. Pardon.
Yes, sir.
We'll probably come back to you. Can you hear the board in its comments back in the back now? All right. We will now declare the public hearing open for this ordinance amendment. Is there anyone in the audience who would like to come and address the board, either in opposition to or in favor of this amendment to Chapter 7 Emergency Services? If so, please come forward, state your name and your voting district. Is there anyone in the audience that would like to address the board, either in favor of or in opposition to this ordinance amendment?
Maynard Penny again. I didn't come up here for this, but having helped to start a volunteer fire department, help secure the land for it, help to build the building, and the chief down there, to take the volunteers and put them subservient to a chief who might be the best in the world, but they've had no experience with, they don't know, and to take that away, put them under them and under the new laws that y'all have. If I were a volunteer, I'd feel like folding my tent and going home. And y'all, you can't pay the paid personnel that would fill in that volume. It simply will not work. I was on a study committee years ago that was primarily requested, Mr. Chairman, from your area. Yes. And even back then it was unspeakable what it would cost, and today it's much more. And I think you really need to respect and work with your volunteers that have taken up the slack over the years and got you to the stage where you are. And that's really all I have said.
Thank you, Mr. Penny. Appreciate it. One thing I did not mention, there's a time limit on speakers. If you're speaking for a group or organization, we will allow you 5 minutes. If individuals, we would ask that you complete your remarks within a 3-minute period. Is there anyone else who would like to come and address the board, either in favor of or in opposition to this ordinance amendment?
Mr. Chairman, Ricky Nadiak, life member of the Legislative Volunteer Fire Company. First off, I'd like to preference my statements by saying that we have several men and women abroad that are protecting the very rights that we have in order to us make public comment like this. So again, while I respect Mr. Penny's comments, I also respectfully disagree with the comments that we are a new age in time that we need to take this to the forefront, bringing, again, encapsulating all of our groups under one person, one chairhead. Even in this day and time that we have individuals that form and serve in our recreational leagues, they are now a confined group now that we need to be doing background checks before they are anywhere around our children or anything like that. So again, we're in a new phase that unfortunately we have to be in that we weren't several years ago. And again, I respect Mr. Penny's comments about the fact that, again, individuals such as him that were the cornerstone and the foundation to get this volunteer system and get these organizations up and running. Again, now we need to take someone at the level of the fire and EMS chief, again, to let them take it to another level, organize this group, and to set forth and embark on a program that, again, when we look at the records management, because again, I've always said, even before the fire chief's position, that the volunteers we have here are staff. They may not be paid staff, but they are staff, and the county is responsible and holds a liability for anything and everything that they do while serving under the umbrella of these volunteer organizations. So again, I highly encourage the acceptance of this ordinance.
Thank you, Mr. Madiak. Appreciate it. Anyone else would like to come and address the board, either in favor of or in opposition to this ordinance amendment?
I'm Bert Chenault again from Bowling Green District. I'd like to speak in opposition to this. You know, the gentleman mentioned a while ago about going to the other counties and what they are doing, like Spotsylvania and Hanover. Caroline, to me, is a county of its own, even though we're growing. We don't have the money that Hanover has. We don't have the money that Spotsylvania has. We don't have the tax revenue. And as we were hearing about the volunteers and all the services they have given through the years, if we had never had them, what kind of a fire department would we have? And that would be what I would like to say.
Thank you, Mr. Chenault. Appreciate your comments. Is there anyone else who would like to speak in favor of or in opposition to?
John Nunnally from Bowling Green District. Excuse me. One thing I've heard that I want to correct, the Commonwealth of Virginia had amended the language in Title 27. A director and a fire chief are the same thing. That's already been done. So to make a big deal about changing it to a fire chief position from a director that's not the issue. Changing their duties may be an issue, but the Commonwealth had already taken care of the terminology issue. And the other thing, Mr. Chairman, you had asked that the county administrator meet with the commission to talk about these changes, and we have not done that. That meeting's not been set up.
Right. Okay.
Thank you.
Thank you, Mr. Nunley. Is there anyone else who would like to speak in favor of or in opposition to this ordinance amendment? If so, please come forward and state your name and your voting district.
Mr. Chairman and members of the board, my name is Robert Mitchell. I'm the fire chief of the Frog Level Volunteer Fire Company. I've been in the department serving as a volunteer for 34 years. I didn't join to be here to get a paycheck. I didn't join here. I joined to protect my community. And in my 34 years, I've seen a lot of changes and so forth that's come about in this county. We are still a small rural county. I'm in favor of this ordinance. It's about time that we had to, my father told me years ago, you can only serve one boss. And in order to have unity and come together, in order to make a more efficient service to protect the citizens of the county, as we've been so fortunate to be doing so as for free for the Board of Supervisors,
There's nothing saying that we are going to disband or do anything, but we need some direction, some consolidation to where we have one voice that approaches the board in order to try to better ourselves and provide better services. So I'm in favor of this ordinance. Thank you.
Thank you, Mr. Mitchell. Appreciate your comments. Is there anyone else who would like to speak in favor of or in opposition to this ordinance amendment?
Mr. Chairman, gentlemen of the board, my name is Carl Hart. I'm the Assistant Chief with the Bowling Green Volunteer Fire Department. We'd like to give our unwavering support for the passing of this ordinance. I don't feel that any citizen in this community really is concerned with the name on the side of the truck that shows up when they call for our services. We need unified leadership, and we must unite under one umbrella to provide this service to our citizens or our customers. Thank you.
Thank you. Appreciate your comments. Is there anyone else who would like to speak in favor of or in opposition to this ordinance amendment? Is there anyone else who would like to speak in favor of or in opposition to this ordinance amendment? One last call. Is there anyone who would like to speak in opposition or in favor of this ordinance amendment? Hearing no further comment, the public hearing is declared closed. Board questions, Mr. Popowitz?
Yes, real quick. I was looking under Chapter 72 of the open burning regulations that were changed.
Yes, sir.
It wasn't too long ago we adopted a set of burn regulations.
Yes, sir.
And I'm noticing that in that, glaringly, that there was a line in the previous regulations that talked about rural burning regulations and that rural and farm operations were exempt from these regulations. Why is that not back in this set?
What section is that, Mr. Popowitz?
Chapter 72, open burning regulations. I'm not sure what section it would be under on the old section, but I know that there was a line, I think it was in paragraph 5 of the old section that talked about that.
Okay. If that's been removed, it's an oversight. The only changes that were proposed there were title changes to reflect the fire EMS chief. So we'll double check that.
All right.
Other questions, Mr. Popowitz?
That was it, Mr. Chairman.
Thomas?
Just one procedural question. I forgot who mentioned it, but I was at the meeting where we talked about a meeting between the Emergency Services Commission and County Manager. I just wanted to know why that didn't happen. Was it scheduling or anything in particular or something like that?
Mr. Chairman, members of the board, staff tried to get through the state fair period, and we did that, and we have now sought Mission Alt's input into helping us to find dates that were amenable to the members of the commission as well as the staff. So we haven't avoided the issue, but I did want to wait until after the state fair in case we just didn't know what might happen, and I wanted to keep my schedule as free as possible. But now we're ready to move into that situation.
Okay, thank you. So we're scheduling, and I know we've got this on the agenda now. We can theoretically we held a public hearing. We don't have to take action right now. We could have that meeting if that's the board desire. Okay, thank you.
Mr. Seeley?
Yes, sir. Yes, sir. Couple of things. I just want to get some clarification on 15-6, leadership, item L, page 7 in our.
Yes, sir.
It says the chief shall have the authority to contract on behalf of the county to the extent necessary funds to provide for public safety during such events. We don't, and this is not new, this is existing. What exactly does that mean, and how much are we talking about? Where does it come from, and how do we track it?
In a disaster.
Well,
But it's just a disaster or emergency.
right, but I mean, somehow, we have to be able to figure out what that is, how we're going to approach that, and we don't want the day that it happens to have to figure this out. I know, I'm saying it's nothing new, but the authority is changing, and I just want to know how we're going to handle this section in the event of the chief now being in charge, and we're giving him authority that typically in the past we had not. Is this just their budget?
I think it's simply, and David, correct me if I'm wrong, I think it's simply giving the authority in the event of emergency where you really don't, you have to make very quick decisions, and you never know what you're going to be faced with, to have that authority to do so within applicable laws and regulations. But I think this is a section that we found in every ordinance that we looked at, simply to not tie the chief's hands in the event very quick decisions have to be made in the event of an emergency.
I'm just looking out for all of us at this point, so we don't come to some point in time where this becomes an issue.
Mr.
Yes,
Lynn,
sir.
you want to elaborate on what Mr. Parton has said?
Yes, sir. This is going to be under Title 44 of the disaster laws, and basically the official declaration is going to have to be declared by the board of the county administrator prior to the expenditures taking place. So this is going to be a known incident that we've already identified as a county emergency. And this is just allowing the mechanism to obtain the resources that are necessary to mitigate the situation.
Okay.
I'm just looking for, I mean, we're given a blanket. I just want to make sure we all understand what we're actually saying in this, so that later on there's not something that happens and there's huge misunderstanding of how much was spent and why. I'm just pointing this out. It's not new, not saying it's new. I'm just curious how we will handle that. Has the board already declared an emergency and we know that you're off doing whatever it's going to take? Because I don't necessarily see that. And you're quoting section 44, and I don't see that listed as part of this.
If you go back to page 6 under item J, yes, sir, it would be under the county's emergency response plan. And basically, the chief serves as the coordinator of emergency management, and the county administrator serves as the director of emergency management under Title 44 Code of Virginia. When we are declaring a state of emergency, and that's going to be a separate set of laws.
Mr. Lane, if I may, I have a question. When we're talking about disasters, emergencies, things of that nature, for the most part, would they not come under the federal FEMA program as reimbursable issues?
It could, depending on what level of the incident is escalated to. It would go from local to state to.
If it gets to the point where it's you're talking about a great deal of money,
yes, sir, it would be reimbursable.
It would be reimbursable.
And we would be responsible for tracking those expenses in the time and so forth.
Understand.
Hey, maybe you can give a real-life example. When we had Isabel, and we declared an emergency, there were some expenditures, and I think most of those were FEMA or Public Works paid for, something like that. So
it was FEMA reimbursement on that. You know, I guess what we're saying is, let's just say North Anna, for instance, something happens there. That's an emergency. Certainly, Mr. Lehman, if somehow that nuclear power plant issues or has problems, we don't want Mr. Lehman to have to go about getting permission from this board or the county administrator to react to that. I mean, thousands of people on my side of the county would end up being hurt by this, and so we've got to try to address it. And so it doesn't make sense in trying to tie his hands as to how we respond to those issues.
See, that's totally different.
If we're talking about small emergencies, yeah, maybe we can say that it's something that's not life-threatening and threatening the public of Caroline County, you get permission. But again, I don't want to tie.
Just a question.
I understand, and we're just trying to give you a response so that you understand. you have any other?
One other comment, and I understand that all the volunteers agree with the ordinance. I hear them.